to talk about in particular, three unintended consequences from this bill, because that's the theme of today's briefing. The first consequence is the constitutional problem. The constitutional issues raised by this bill have been discussed already, but I want to highlight them because the danger is that this bill has been one that's been promised to reduce uncertainty, create more predictable property rights, and it's going to have the opposite effect because there's a constitutional cloud over this bill which is going to serve as a fodder for litigation and a frankly full employment act for people like me who will now spend the next several years challenging all the various aspects of this bill that raise constitutional problems. The biggest constitutional flaw in this bill is the first to invent system. I'm sorry, the change from the first to invent system. This bill creates something called first inventor to file, or really first to file. For 220 years, we've had a system that we've heard gives patent rights to the actual inventor of a new device or invention. This bill changes that so that the first person who wins the race to the patent office and files an application will be entitled to the patent. This bill runs contrary to the understandings of James Madison, Thomas Jefferson, John Marshall, who was the first great Chief Justice of the Supreme Court. All of them understood that the patent language in the Constitution requires that only an actual inventor can get a patent. And what this bill does is it changes that system so in cases of controversy or conflict between inventors, the one who won the race to the patent office gets the patent. In fact, the main, I'm not going to rehearse all of the constitutional arguments because that would be a separate briefing in itself, but the main defense of the constitutionality of this bill is that the word inventor is in the title and in the text of the bill. And that's like putting lipstick on a pig. I mean, you can't change the constitutional flaw by borrowing the word inventor and putting it in the bill. Because the salient fact is, the undeniable fact, is that when there's a conflict under this bill, when there's a conflict among different claimants to an invention, the patent is awarded not to the actual inventor, but to the person who filed first. And that's the departure from 220 years, which raises a constitutional problem. And no matter how you label it or name the bill, you can't erase that problem. Okay, the second unintended consequence of this bill is a special interest provision called Section 18. Section 18 is special interest within special interest. If this whole bill is sponsored by or favored by large multinationals, this Section 18 bill is the financial services bailout provision. What Section 18 does is it gives banks and financial services firms a special right, unavailable to anybody else in the United States or the rest of the world, to challenge business method patents that they're accused of infringing. So everybody else in the world has certain rules about how to challenge patents, either at the patent office or in court, and banks have a separate additional right that nobody else does. Why is that? Well, the banks have been successful in getting this in because they want to challenge retroactively patents that are already existing. In other words, this provision, Section 18, applies to patents that have already been found valid by the patent office, in some instances multiple times, because there's an examination procedure, then there's a re-examination procedure. And some of the patents in question have been found valid in court, but the banks will get a separate opportunity to challenge them retroactively. This bill, this provision, creates all sorts of problems. First, it complicates, it violates, frankly, it violates our international trade obligations because under international trade treaties called TRIPS and similar provision, all signatories are prohibited from granting special privileges to particular industries. Our government spends a great deal of time trying to persuade China not to grant not to devalue American intellectual property, and not to grant special protections to various industries in China. We are now committing the same sin if we pass this bill, because Section 18 creates a special provision just for banks. And to show you how outrageous this is, really, one of the main proponents of this bill is Microsoft. And Microsoft released a letter in the spring opposing Section 18 because it realized that Section 18 violated international trade commitments. And so Microsoft was willing to sponsor all the rest of the bill, but even Microsoft could not stomach Section 18. Another big sponsor of the bill, Procter & Gamble. Procter & Gamble's general counsel was somebody we've had all discussions with. When he testified in the House in March, he said that he didn't agree with Section 18 because why should someone be allowed second or third or fourth bite at the apple when no other industry would be entitled to that benefit? So even the proponents of the bill have problems with Section 18. And it creates additional, I think, cost issues at a time when we are all concerned about the burden on the patent office. The proponents of Section 18 have refused to change it, to weaken it in any way. They've rejected plans like, well, what about patents that have already been found valid multiple times? Why should the banks get a special right to challenge them? There have been proposals to say, let's change Section 18 so that if a patent has been found valid at the patent office or valid in court, it can't be challenged again through Section 18. That proposal is not on the table. The banks won't stand for it. So at a time when the patent office is overwhelmed and there's a 3-year delay in processing patent application, so that for many companies a patent is obsolete by the time it issues, we're adding in Section 18 additional burdens to the patent office by making it review patents that have already been found, in some cases repeatedly found to be valid. This provision also creates its own constitutional problems because it's retroactive and it applies to existing patents. The Supreme Court has said that patents are property just the way land is property. If the government builds a highway through your front yard, it has to pay you compensation. If the government abrogates patent rights by enacting Section 18, it will owe compensation to the patent holders. What this means is the banks will be allowed to use patents and the taxpayers will have to pay just compensation to the patent holders in the end. So this is a second bank bailout, and on top of the one from the TARP and all of that, this is going to be a bank bailout bill that will transfer the cost of infringements from banks to the public treasury. But certainly is going to generate additional litigation for people like me, because we'll be able to sue on behalf of companies whose patents are subject to Section 18. And when the banks invoke Section 18, my clients will be allowed to challenge that and sue the government to try to get money. And that's wrong. I would prefer not to be doing that kind of work. And the way to cut it off is not to have Section 18 in this bill. The last category of unintended consequences I want to discuss, I'll also lead into our last speaker, is the fact that this bill is going to chill innovation and hurt American jobs, because it's going to discriminate against startups, small inventors, research institutions, particularly small and medium universities. You can see the lineup on this bill is just big versus small. It really is. It's the big companies favor it, small inventors and startups don't. And the reason is because this bill systematically discriminates against small inventors. Here's just to put things in as plain relief as you can imagine, the Wright brothers would not be eligible for a patent under this bill. Hewlett and Packard, who came up with the variable frequency oscillator, would not be eligible for a patent under this bill. So why is that? Because the bill changes something called the grace period, which is vitally important to small investors. Today, and you're going to hear from an angel investor who does this work every day. If I'm a small inventor, I will not be able on my own to go from the idea to making a prototype to commercializing it to producing it, I can't do that on my own because I'm not going to have the money. I need a partner. I need an investor, a venture capitalist, an angel investor, someone who will help me through that process. Because even applying for a patent takes $20,000 and up to get a lawyer and process the application in the patent office. So today, there is an iterative process, a back and forth between inventor and investor, where inventors come up with ideas, get a little bit of money, go back to the investor, get a little bit more money, fine-tune the idea, fine-tune the invention, eventually file for an application, file a patent application, at the end of what can be a very long process of chasing down dead ends and all of those. All of that today can happen because current law does not disqualify an inventor. When the inventor makes certain disclosures to third parties, makes certain uses, the Wright brothers flew their airplane before they patented it. This bill changes that and eliminates the ability of inventors to make public uses and to make certain disclosures in order to promote their commercialization of their invention. And the net impact of this bill on American innovation is going to be astounding. And it's unfortunate that it has flown under the radar. It's unfortunate that for example, when Section 18 was added to the bill, it was added in the Senate as a manager's amendment. Never got a hearing. In the House side, there was a hearing on Section 18. Well, Section 18 was raised at a hearing, but only by witnesses from the Financial Services Roundtable. No opposing witnesses were involved. And I think that's just that's in a microcosm the problem with this bill. So anyway, those are the three unintended consequences I wanted to raise, and I'll turn it over to the next speaker.